Hello, everyone, and welcome to this special Brennan Center for Justice event. For those of you joining us for the first time, the Brennan Center is a nonpartisan law and policy institute that works to repair, revitalize, and when necessary, defend our systems of democracy and justice. I'm Alicia Bannon, the director of the Judiciary Program at the Brennan Center, and editor-in-chief of a new Brennan Center project, State Court Report. State Court Report is a resource for news, commentary, and cutting-edge scholarship about developments in state courts and constitutions. And this is the first in a series of State Court Report-related events. At a moment when the U.S. Supreme Court is stepping back from protecting many fundamental rights, and we'll hear a lot about that tonight, state courts are taking on new prominence. On the newly launched State Court Report website and in events like this one, experts will break down the complexities of state constitutional litigation happening across the country. We hope you'll check out the website, statecourtreport.org, sign up for our newsletter, and keep coming to events like this one. We're so excited to have you joining us today, but before we get started, there are just a few housekeeping notes. First, we will leave time for questions at the end of this discussion. If you have a question you'd like to ask, please feel free to add it via the YouTube and Facebook chats. Second, civility is important to all of us. Those who post rude or intemperate language in our message streams here on YouTube and Facebook will be removed from the conversation. Live closed captioning will be provided. Follow along with the conversation on social media with the hashtags Brennan Center Live and hashtag State Court Report. And a very big thank you to our partner, NYU Law's Birnbaum Women's Leadership Center. Now to today's program. I am honored to pass things off to Emily Bazelon, staff writer at the New York Times Magazine and Truman Capote Fellow for Creative Writing and Law at Yale Law School. Welcome, Emily.
Thank you so much, Alicia, and good evening to everyone. I'm so pleased to be moderating this event with three fabulous panelists. So I'm sure it will not be news to many people joining this call that there is a new conservative majority on the United States Supreme Court. And I think the country is in a moment of kind of prolonged adjustment to what that means. One of the obvious consequences is that the court is less interested than some past courts have been in protecting people's rights through the federal Constitution. And nowhere has that been more true than in the area of reproductive rights. And so when we go back to June 2022 with the court's decisions in Dobbs, we see a really earth-shattering event, the loss of a constitutional right to abortion that has had all kinds of aftershocks. And one of them has been really the increasing importance of state constitutions and state courts and other state processes like ballot measures. So I think the Brennan Center's move to issue this new state court report is incredibly timely. And I'm really excited to talk about some of these issues tonight with our three panelists. We have Cheri Beasley, who is the former Chief Justice of the North Carolina Supreme Court, David Cohen, who is a reproductive rights scholar at Drexel University, and I'm going to welcome back Alicia Bannon of the Brennan Center and State Court Report. Hello to all of you. Let's start off with David. David, you know more about how abortion rights has developed than most people in the world, at least in terms of the United States. And your research is cited many times in this report. Can you just walk us through the landscape for state litigation about abortion rights post-Dobbs?
Sure, and thank you to the Brennan Center for having this event and having me and all the great panelists with me tonight. So since Dobbs, like Emily said, there's been renewed attention on state constitutions and state courts. Now, to be clear, state constitutions and state courts have been really important in abortion for decades. There have been cases in state courts way before the Supreme Court overturned Dobbs, even when there was a constitutional right under the federal Constitution to abortion. And those cases have paved the way for increased access in many states around the country, and those cases still matter today. For instance, decisions from the Kansas Supreme Court, Minnesota, New Mexico, New Jersey Supreme Courts in the past have been important in the past and continue to be important today. But we're seeing a sort of broadening of the landscape of state courts and state constitutions that matter post-Dobbs, because now that the federal option has been closed off, at least under the same theory as Roe v. Wade, litigants are going into state court to try and make somewhat the same claims as in Roe v. Wade, or novel new claims under new theories to try and protect either the broad abortion right or a narrower right in some circumstances. And we've seen some surprising and some not at all surprising outcomes since Dobbs. So, for instance, in the surprising outcome category, we've seen the Supreme Courts of Oklahoma and North Dakota both find a constitutional right to a narrow right to abortion under their state constitutions for people who are experiencing life-threatening pregnancies. The statutes in those states did not grant a right to abortion, but the state Supreme Courts in those states said there was a right. Again, that's narrow, but it's from states that people might not otherwise think are going to protect abortion rights. We've seen protection from states like Wyoming, lower courts in Wyoming and Utah that have found that restrictions in those states go too far and have kept abortion legal in those states even post-Dobbs. And those are two states that I think if you looked at many of the pre-Dobbs maps, people would say those are the states where there's going to be an abortion ban in effect pretty soon after Dobbs. But so far, and the state Supreme Courts have not ruled in those states, so far abortion remains legal in Wyoming and Utah because of lower court decisions in those states. We've seen Iowa, the Supreme Court in Iowa and Supreme Court in Montana block abortion bans or abortion restrictions post-Dobbs, and abortion remains legal in those states. But then we've seen sort of some states that do the complete opposite. We've seen decisions from Idaho, Indiana, South Carolina. And South Carolina is an interesting one I just want to touch on quickly, a little more than just in a list. In South Carolina, the state Supreme Court initially in early 2023 found that the state's 6-week abortion ban was unconstitutional under the state constitution. But then the Chief Justice, the only woman on the court, retired, mandatory retirement age. She was replaced by an anti-abortion justice. And just a month or two ago, the case was reheard by the South Carolina Supreme Court and allowed that abortion restriction to go into place. And that has decreased access to abortion in the South. And importantly, we're waiting on decisions from several really important state Supreme Courts with respect to abortion bans in those states. And so we are waiting on a decision from the Florida Supreme Court, probably the most important state that remains in terms of state litigation, because Florida has been a state where a lot of people in the South have fled to get an abortion because of the decreased availability of abortion and abortion bans in a lot of other Southern states. Abortion has increased drastically in Florida, but there's a 15-week ban that is currently before the Florida Supreme Court. Oral arguments were last week or 2 weeks ago. And if the 15-week ban is allowed to go into effect, a 6-week ban will then take effect, as the legislature has said. And then I just want to flag one other type of case. And these are cases before the Missouri and Ohio state Supreme Courts that are currently dealing with abortion-related referenda. Those referenda are going to be on the ballot in Ohio in November and probably next year in Missouri. And the state courts have been intimately involved in protecting that process and guaranteeing that process is fair and in compliance with the state law. So we've got a lot of different types of state litigation in state courts and very active state Supreme Court justices deciding these key issues post-Dobbs.
Thank you for that. That was super helpful. It reminds me that I think one of the reasons that state court and state processes generally don't get as much attention is just that you have to keep track of more moving pieces. I want to go next to you, Chief Justice Beasley, to talk a little bit about how you think about precedent. To return to South Carolina, we have there a decision at first from the South Carolina Supreme Court that was relatively protective of abortion rights. Then the court's membership changed and it flipped. It reversed its earlier ruling. In North Carolina, which is your state, there's also a new conservative majority on the state Supreme Court, which has overturned recent rulings on other issues, including partisan gerrymandering and voter ID. I wonder how you think about this issue of precedent now that you're no longer serving on a court yourself. How do you look at what other states are doing? Precedent is a pretty malleable concept. What do you make of what's happening?
Well, Emily, it seems it's become a malleable concept. Traditionally, it really hadn't been. I mean, that's why we call it precedent, that courts felt a sense of legal tradition and following the rule of law and preserving integrity of the court in following its previous decisions. Certainly not always. I mean, certainly we wanted slavery abolished, but consistent with the times, courts have always generally followed precedent. And you're right, in North Carolina, the North Carolina Supreme Court recently overturned two of its decisions on gerrymandering and voter ID. In a 2-year period in North Carolina, 5 justices left. I was one of them. And then 5 more were elected. It is a conservative leaning court. And I think it's noteworthy, of course, that we see the Supreme Court of the United States has just in Dobbs overturned Roe after 50 years of this case being legal and constitutional. And all of a sudden it didn't become legal and constitutional. And the court's rationale was essentially that the court in 1973 abused its judicial authority and did not have sound reasoning, which is dangerous. And so precedent should matter, and the public really has should have an expectation that the court will offer sound reasoning and not be hasty in making judgments around the rule of law.
And do you think there's any room for overturning precedent? I mean, obviously there have been some incredibly misguided, wrong, unjust decisions of the Supreme Court, from previous eras. And so I think judges often are debating what's the right standard? How do you justify overturning, a terrible ruling like Dred Scott? How do you make room for that while holding on to the kind of respect for tradition? And I think also recognition of how important stability is for law in so many instances. How do you balance those values?
Well, the Constitution, both federal and state, generally offer great guidance for judges around particularly civil rights protections and other kinds of constitutional protections. And so it makes a lot of sense that Dred Scott was overturned and that we have a 14th and 15th Amendment. But it does not really make sense that after 50 years, Roe was overturned. And of course, there is a greater issue here around how we found ourselves in this place and why the court is making decisions in the way that it currently is. And so I think it's important as we think through the court's actions around Dobbs and so many other issues around gun rights and so much more, that we really have to be thoughtful about what that means for the rest of us in this country.
David, I'm going to go back to you and then I'll turn to Alicia in a minute. But I just want to talk a little bit more about litigation. So in addition to challenges to abortion bans, there are also some lawsuits going that are trying to expand access to abortion. And that includes a case you're involved with in Pennsylvania. How have some state constitutions offered greater protections, a kind of higher ceiling for abortion rights than the one that existed previously with Roe? And how are you thinking about precedent in the case you're bringing in Pennsylvania?
Yeah, as a litigant and as a lawyer who represents abortion clinics, which I do in Pennsylvania, I think there's a slightly different way of thinking about precedent, especially precedent that you think is damaging to your client's interests, that you can look at precedent and say, well, we can take that precedent and we have to apply it. But there's another route, which is we can try to have it overturned. And here in Pennsylvania, on behalf of the independent and Planned Parenthood abortion clinics, I and lawyers from the Women's Law Project and a private firm sued the state back in 2019 because the state does not cover abortions under Medicaid. And we allege that that violates the state constitution's guarantee of equal rights, both under the general equal protection clause and the Pennsylvania Constitution, unlike the US Constitution, has an equal rights amendment. And so we said this is discriminatory under the state constitution. But we have a big hurdle to overcome in winning this case, which is that in 1985, the Pennsylvania Supreme Court unanimously rejected these identical claims. And so here we are, we filed the case 34 years later, and here we are 38 years later in 2023. We argued the case before the Pennsylvania Supreme Court last October. We have not gotten an outcome. I was hoping we would get a decision like this morning so that I could talk about it tonight, but we haven't. But we have to overturn that precedent. We confronted it head on. We have our arguments for why the precedent should be overturned. Because we think that the law in Pennsylvania has shifted, and especially in how it thinks of its constitution separately from the US Constitution and the US Supreme Court, and that there's new evidence that's been brought out about the harms to people who want an abortion for Medicaid abortion bans. And so we presented that evidence to the Supreme Court, and we are hoping for a favorable ruling. And I think it's important to always think about that option and think about all the ways in which overturning precedent has led to progress and change and good in this country. It's not always bad. Dobbs, I think, is a bad version of overturning precedent. But when I like to think of the problem with Dobbs, I don't like to, and I normally don't criticize the fact that it overturned a precedent. The fact of overturning a precedent, I think, can be a really good thing for the rule of law even. I think they did it in a really bad way and without good justification. I think that's the problem. And if ever this US Supreme Court were to be more favorable, I would be front of the line arguing to overturn Dobbs, whether that's next year or 50 years from now or 100 years from now. And I think we need to always think about that as a strategic option, whether it's state court or federal court.
Thanks for that. Alicia, I want to ask you about ballot initiatives. So in his majority opinion in Dobbs, Justice Alito said that what the court was doing was inviting voters to weigh in on how much abortion access to allow in their states. And obviously voters can do that by electing representatives who then pass laws. But in some of the states in the country, 23 states, they can pass ballot initiatives that citizens initiate by launching petitions and signature drives. To me, one of the most surprising outcomes since Dobbs has been the way those ballot measures have played out across the country. So the first one was in August of 2022, just about 6 weeks after Dobbs. The voters of Kansas defeated a measure that would have imposed probably new restrictions on abortion. Then you see Montana and Kentucky, two other conservative states, similarly defeat ballot initiatives. And then the following that November, Michigan, which is a perennial battleground state, that ballot initiative asked voters to enshrine state constitutional protections to abortion in the face of a ban that was temporarily blocked in court. And the voters said yes and changed the law in Michigan to protect abortion rights. Now there's another initiative that David mentioned coming up in Ohio in November. That is a more conservative state than Michigan. The pattern so far, though, is that when voters are asked directly about abortion access, they are not interested in bans, even in quite conservative states. And I wonder what you make about this as you're working on the state court report.
Thank you for that question. And I'll say for folks in the audience who may not have seen it yet, Emily had a fantastic piece in the New York Times Magazine just this weekend about ballot measures. So if you haven't read it yet, everyone should definitely read it. And I do think it's been one of the most interesting things that we've seen in the aftermath of Dobbs. And just stepping back, one of the ways that state constitutions are very different from the federal constitution is that they are far easier to amend. And in particular, as Emily was saying, there are a number of states in which you can have citizen-led initiatives that don't require going through a state legislature to amend your state constitution, and particularly in states where you may have highly gerrymandered state legislatures, like in a state like Ohio, those ballot measures can really be, kind of the only opportunity that the public may have to be kind of shaping the legal environment in their state on an issue like abortion. And so, when we're talking about, state constitutional change, it's not just how courts may be interpreting these provisions going in the future. They may be interpreting actually different provisions than existed, today as we see these amendments on the ballot. I think, one thing I'll just flag, looking at it from the perspective of the role of state courts, and David mentioned this a bit when he was giving the overview. His overview is that one way that state courts are really front and center is in interpreting challenges or addressing challenges related to these kinds of measures on the ballot. So, for example, last year in Michigan, and as Emily noted, in Michigan, the voters voted to amend their constitution to institute abortion protections. There was a challenge to the petition. Basically, there was an effort to boot it off the ballot in the first place, arguing that the petition, the space between the words was too close together, and that was given as a basis to not put it on the ballot. And it was a divided court, so there were two justices on the Michigan Supreme Court that would have used that as a basis to keep it off the ballot and not actually put it before the voters. But they lost out. The majority of the court said no, that is a small technicality. There's no evidence that voters were actually confused, and so this should go on the ballot. And, right now in Ohio, we're seeing litigation. There was previous litigation in Ohio trying to keep that abortion measure off the ballot. Right now, there's a pending suit with a challenge by the supporters of that ballot measure, saying that the language that the ballot board has put forward, actually, that's going to appear before voters, is itself misleading. So there's a lot of different litigation that we're going to see, now and in the years to come, I think, around these ballot measures, as people turn to courts as one tool as they're trying to either stop things from going on the ballot or ensure that voters have fair and accurate information.
Yeah, just to follow up on that, I mean, one thing that I have noticed is that while ballot measures are nonpartisan, the responses of some of the state Supreme Court to challenges like the ones you've described have been splitting along party lines. And I just wonder how you think about that, the kind of partisan affiliation of these judges and justices. We sort of want to imagine that political affiliation and partisanship is not driving how judges make decisions. And yet, we're seeing this pattern play out. And I think there might be some exceptions, however, to that, as you see state courts respond to ballot measures. Now I'm thinking about the Missouri Supreme Court, but I wonder what you make of this part of the puzzle.
Well, I think certainly the Michigan example underscores that, it matters who's on the bench. There were two justices on the Michigan Supreme Court that would have kept that measure from reaching voters in the first instance. At the same time, I think it's actually been a bit of a mixed story in that regard. So, for example, there was a lawsuit in Ohio seeking to keep that an abortion measure off the ballot, and the court unanimously rejected that. So I think we also see instances of courts actually not breaking along ideological or party lines, at least in some instances where the issues are fairly straightforward. But, it's certainly the case, in 38 states, elections are used as part of the system for choosing judges. State courts are often far kind of more closely tied to the rough and tumble of politics than we might be used to, with federal judges that have life tenure and are highly insulated in a lot of ways. So certainly those political dynamics are part of what we need to be looking at if we're trying to understand state courts and the decisions that are coming out of them.
Thank you for that. Chief Justice Beasley, I want to go back to you. So we've seen, I think, heightened interest in state judicial elections in the last few years, certainly more money pouring into these campaigns. And this year, Wisconsin saw the most expensive judicial election in U.S. history, and reproductive rights were a central issue. Can you offer your personal perspective as someone who's had to do this job in this highly politicized environment? What's that like?
I had 5 elections, judicial elections, 3 of which were statewide. And my last election was for the office of Chief Justice. And at the time, it was the most expensive race in North Carolina's history. It is concerning. Clearly, lots of special interest groups have been weighing in state judicial races, and we certainly saw the epitome of that in Wisconsin. And I'm really concerned that I'm not naive enough, I don't think, to believe that judges may have leanings one way or the other. But I do remember a time in North Carolina when the court, about 90+% of the time, agreed on most issues. But I am concerned deeply when judicial candidates are expected to stake themselves out or take positions on issues that are likely to come before the court. And when there's an expectation from special interest groups that the candidate will take the position and then follow through. What we're really seeing is an erosion of trust and confidence in state courts. Many of state court justices and high court justices are elected now. And I don't know if elections instill more confidence or not. I do know that party systems do most of the vetting. But we certainly see on the Supreme Court of the United States a real issue around trust and confidence. The more information we have about their personal lives, and we in some way make a nexus between that and the decisions that they're making in these really critical cases. So I do believe the harm there is twofold, that we see pressure from outside groups and an expectation that judges will rule a certain way. And also that this leads to an erosion of trust and confidence in our courts to be fair and impartial as judges are charged to do.
Yeah, I feel really torn about this. I mean, there's a part of me that just doesn't really understand how judges can run for election without raising these issues. And I wonder how you think judges, when they are up for election, how should they handle sensitive topics like abortion? What should they say or not say?
I as one who's run a lot, I just didn't talk about abortion, and I didn't talk about specific issues. I didn't talk about my personal beliefs about issues. I will also say that things have changed. And even in my last election was in 2020, and in a very short period of time, candidates are expected and often deliver on taking positions on issues that could or may or likely to come before the court. I just think that trend is deeply troubling.
David, as someone who litigates in state court, how do you think about judicial elections? Are you hoping that people will make commitments about their values so you know who to vote for? Obviously, it's off limits to say that one would vote a certain way in a pending case. But the Supreme Court of the United States protected the First Amendment rights of candidates for judicial election to talk about contentious legal and political issues. So, I think there's just it's not clear where those lines are. And I wonder, as someone who is bringing these cases, how you think about this.
It's important to pay attention to judicial ethics, and you don't want judges who have prejudged cases. You don't want judges who have been involved in the issue in a way that compromises their objectivity. But the reality is people have views, and in states where there's an elected judiciary, and I think a lot of people question whether that's the best way to have a judiciary, although appointments through political process also has concerns. In states where there are elections, I do think that people should know what they're voting for. And it shouldn't be a black box of saying, we've got this really important election for this person who's going to have this really important job for decades. And yet we don't know what they feel about some of the major concerns and major issues that might present themselves for the next couple of decades. It would be a strange, I mean, if you're in a world where there are judicial elections, and like we said, most states, the majority of states, that's the way judges are put on the bench. If we're in that world, which I think is not the perfect world, but if we're in that world, then there's some sense that this is a component of democracy and the people should have their voice and the people should know what they're voting for. So I think there's a really fine line, but as advocates, as people who are trying to understand the law and use the law in court, you really hope to know what, at least some sense of what you're voting for.
Alicia,
Emily, if I could just,
go ahead.
if I could just jump in on the judicial selection around merits and appointment. It's true. I agree with David that most judges are elected, and it is really hard to glean, other than the vetting that's informal through party systems around one's judicial philosophy. What we know, though, and all the data shows us that judges who are appointed versus judges who are elected are not necessarily more diverse. And certainly that has to be a concern if we're thinking about courts that reflect the demographics of their states. And so I just offer that he's right, it's not perfect. It's not perfect. And we do have to have a way to figure out how we're electing fair and impartial judges. And I agree with him, there is a fine line. It is just often an expectation by these groups that are pouring in lots of money that we call dark money, that judges vote and rule a certain way in these really pivotal cases.
So I just want to remind the audience there are about 10 minutes until we'll start the audience Q&A. And so if you have questions for our esteemed panelists, please queue them up and we'll go through them. Alicia, as you're editing state court report and thinking about what you're seeing across the country, do you have some thoughts about judicial elections and the role they play and the expectations that voters have? I mean, one thing I always wonder about is what can voters really be expected to know about these candidates? It can be really hard to keep track of who's who, especially if you're facing a really long ballot, if you're electing not only Supreme Court justices, but also local judges as well. When I used to live in Philadelphia, I always found that to be very vexing. I just didn't know what to do, which I'm sure since David lives in Pennsylvania, he is aware of what I'm talking about. I wonder how you think about these issues from your perspective as editor of this report.
Absolutely. And it's something that we've studied for a long time and have tracked judicial elections for a long time. And I do think the fact that historically these elections have been typically very low information races is a big concern, because these are important positions. They're very high stakes. They're, helping set the legal landscape in a state. And, going to Chief Justice Beasley's point about all of the money and special interest attention these races get, oftentimes the only information that people are having about, judicial candidates might be the subject of an attack ad by, a dark money group. And so, I do think that there's a real urgency around, real deep public engagement and public education about the role of state courts, what they do, and then who's actually running for these positions, so that people are engaging meaningfully in shaping their courts.
Thank you for that. Yeah, go ahead.
As someone who lives in Philadelphia still, and yes, every off year we have a ballot that has dozens of judges on it. And I always joke, I mean, it's not really a joke, but I'm a law professor and a lawyer, and I don't know most of the people on that. And I have to go to, obscure sources to figure out who these people are and who to vote for. And if I, a super informed voter on this exact issue, have struggled to know who to vote for in this really important election, I think of the challenge for everyone. And that, it's not just our state Supreme Court justices that we vote for, it's down to traffic court and everywhere in between. And so you're just bombarded with this massive list of people's names you don't know. And it's really hard to think that we're getting the best judiciary possible with that selection process.
Yes. I mean, I do also think, and I think one of you alluded to this earlier, that when you appoint judges, it may be better. I mean, certainly it solves the problem you were just describing. It's also still tied to the political process, right? I mean, we think of the judicial branch as a separate branch of government, and certainly it is, but we don't have a way of completely segregating it from electoral politics. That's just sort of part of how the American constitutional system works. Even obviously in the federal system, we have the president nominating justices and judges to the federal bench, and then we have the Senate with its role of advise and confirm.
Well, and I'll add just to that, there are some interesting examples in states of different ways of structuring appointment systems, though. So, for example, some states have used what's called often a merit selection system, where you have a judicial nominating commission that vets candidates and presents a short list to the governor. And, the devil is always in the detail about how those commissions are structured. Sometimes they're just, a kitchen cabinet for the governor and not independent. But in some states, there's actually quite a bit of diversity in terms of who appoints people to those commissions. There can be partisan balance requirements. There can be professional diversity requirements. And in some states, I think they do inject a level of independence in the process that can be helpful. So I think state courts are also interesting to look to as kind of some potential models of alternative ways to think about approaching judicial selection.
So, Alicia, if it were up to you, would that be the system that you would choose for all the states, for the federal bench as well?
Well, I guess we've done at the Brennan Center some policy work around judicial selection in the states, and we've argued for at least for state Supreme Courts. So when you're looking at those top courts, that having a publicly accountable appointment system would be is something that we encourage states to look at. I think another dimension that people often don't think about with respect to state courts is that judges in both appointment and election systems are subject to reselection. So a sitting judge is facing an election or facing a reappointment decision, and that can really create concerns with respect to judicial independence. So that's another place I think to look at is, are there ways to better insulate judges on the back end so that they're not looking over their shoulders when they're making these critical decisions.
And is there research or any evidence about how to address the issue that Chief Justice Beasley was raising about representation, just making sure that a kind of insider group doesn't self-replicate in a way that doesn't reflect, how what a state actually looks like in terms of race and class and gender, et cetera?
Well, I think that so there's research suggesting that at least at the Supreme Court level, elections have rarely been a path to the bench for people of color. Even in states that use elections, it's been interim appointments that have been the principal path that people, for if you look nationally, how people of color have reached the bench. But both elected and appointed systems have not, writ large, been effective. We still have a real dearth of diversity. And I think a lot of that comes from, a question of values and sort of what's getting prioritized among the various decision makers in terms of who has that path to the bench.
Thank you for that. I'm going to ask one more question and then turn to the audience. Excellent questions. So we have a federalist system, and that means that in some instances we have one set of national rules that governs everywhere, set by Congress or set by the federal courts. And then on other issues, we have a state-by-state approach. What do you think the implications are for allowing every state to regulate abortion differently? David, maybe I'll start with you, if you don't mind.
Well, there's a lot of confusion. A lot of people are really confused because in some states, the law is changing quickly and changing sporadically as decisions take effect or they get blocked. And there's also just the sense that something is so important as to be able to choose your destiny, choose what to do with your body, choose what to do with your life, should not be determined by where you live. That it should be something that is subject to a national standard of a right. I mean, that's sort of the essence of what a national right is. It means it's uniform for everyone. And so there are some things like, say, this local speed limit that we think makes sense. Every community says what they want. But when it comes to a basic human right, to have it subject to different rules in different parts of the country, that strikes me and a lot of people as unjust. And so it does create this patchwork, this confusion, and this really sort of different landscape based on the randomness, basically, of where you live.
All right, let's turn to these terrific audience questions. So the first thing I want to ask from a member of the audience, what form of protest would be the most meaningful and impactful on this front? You know, if you're someone who's distressed about the direction abortion rights is going in this country, in any direction, what's the most effective vehicle for expressing yourself?
Voting and the empowerment in voting. I participated in marches after the Dobbs decision, and I saw the outpouring of emotion and outrage in North Carolina and all over this country. And that's important, and it's powerful. It's powerful to have those displays. But if we're really serious about protecting the rule of law, if we're really serious about Roe and the protections that women deserve around reproductive health, if we're serious about combating the dangerous conditions that women can often find themselves in, and combating the paternalistic nature of this Dobbs decision, people have got to vote. And it is the most powerful thing that we have. That's, unfortunately, there is gerrymandering, and the right to vote is certainly under attack. But I do believe that there's some at least anecdotal indication that there in some communities, people no longer believe in the power of voting. And we know that institutions would not be attacking the right to vote if it didn't matter. And so I think it's important to really impress upon those around us that if we really care, and I know so many people really do, and feel really a sense of hopelessness about how do we fix this, we really have to vote.
Voting is just such an interesting dilemma because one at a time, it's easy to understand why people feel like their votes don't matter. And yet, as a form of collective action, there's just nothing more powerful and important.
Yeah, I mean, if you look at what's happening in Wisconsin, today was the first day since Dobbs that there's been legal abortions performed in Wisconsin. And that is a direct result of the election in April of the new Supreme Court justice. Now, she hasn't ruled on any abortion case yet. She took office on August 1st, but the clinics in Wisconsin who were laboring under, or were closed under a law from the 1840s, I believe, that they thought would be enforced, they are now confident it won't be enforced because there is a pro-choice, they believe, majority on the state Supreme Court. So yesterday they did their first abortion counseling, and there's a 24-hour waiting period in Wisconsin. And today the first abortions occurred in since June of 2022, all because of voting in April. So absolutely, that's important. Now, there's a few other things too. I just want to stress. In every state in the country, there are people and groups who are working on these issues, and you can talk to them about what's the most effective thing to do in that state. And that may be different from every state, from each state from each other. And I would certainly look to the people who are doing the work on the ground, familiar with what's most effective there. That can take the form in helping to drive patients to appointments in other places, funding abortions, escorting at clinics, helping with clinics that have closed and support the efforts that they are still trying to provide care to people in the state, other forms of care. It's going to be different everywhere. And so it's important, if you're interested in protesting what's happening right now, connect with the people in your state, town, city that are working on this and see how you can help, because there's absolutely a way you can help.
I just want to prompt you if you want to talk about one more aspect of this, which are abortion pills and self-managed abortions, which we know are becoming more and more prevalent across the country and are a way that people are trying to take care of themselves in red states. I know that's something that you work on, and I wonder if that's part of the equation here.
Absolutely. I mean, before Dobbs, over 50% of abortions in this country were by pills, not by procedure. It's a 2-pill regimen that is approved by the FDA and is safer than Tylenol, Viagra, and penicillin. Very safe. And for some people, that's how they choose to get an abortion. Now, in some states, the states with abortion bans, for people who don't want to leave the state, it is the only way to get an abortion. There's information on website Plan C, plancpills.org. I think that's the website. And that will let people choose the state where they are and find out information about obtaining pills. There are legal risks involved in some of the methods, but the information is laid out there for people to determine what's best for them. And there are volunteer informal networks of people who are working to distribute pills in red states. And they're hard to stop. I mean, the reality is that what they're doing has legal issues, but it's hard to stop because it's just hard to stop people distributing pills. And so people are still getting abortions, and there might even be some indication from the numbers that abortions have gone up in this country post-Dobbs because of the work of people on the ground to make sure that it's as accessible as possible in an unjust world.
Right. And an important indication of a fact we've seen in other countries, which is that making abortion illegal doesn't prevent it from happening. People will still seek it out. Another question from the audience. Do all of you think that a middle ground on abortion law is possible? Alicia, maybe I'll start with you if you don't mind.
No, thanks. That's a good question. I mean, I guess it depends on what you mean by middle ground. You know, I think it's interesting what we've been seeing with the ballot measures that we were speaking about. If you look at, you know, kind of public opinion in a lot of places, you know, at least there's been perhaps a disconnect between what we're seeing coming out of at least some state legislatures and what the public at large, in a particular state might want. You know, that then interacts with, a whole other set of issues that's working their way through state courts right now around issues like gerrymandering, where you have a lot of political institutions that aren't very representative of the public. And, you have a U.S. Supreme Court. This is another place where the U.S. Supreme Court has, shut the door to federal constitutional challenges to things like partisan gerrymandering. But there are states where, state constitutions are a potential alternative place to turn to, and there's a mixed record there. We've seen a number of states now enforce those protections. We've seen others that have not, or in a state like North Carolina flip-flopped when we had a new court.
Chief Justice Beasley, do you want to take a crack at this one?
I too, like Alicia, was thinking about the term middle ground, and it's really hard to legislate what that looks like. And when we know that these decisions really should be made between a woman and her doctor, and that the government really has no business in the exam room, it is, and we know the horror stories. We know what's happening. I mean, David is right. There are amazing folks and groups who are out there working and making sure that people get the care that they need. But there's so many people who don't get the care that they need, and their lives are endangered because of legislation that is short-sighted and creating a real danger for folks. So the middle ground in my mind is what the law was. The law never said, I mean, we know the propaganda around abortion after birth. There's no such thing. And so the law really was that a woman and her physician will make the decision in a safe way. And it's just impossible to legislate specific circumstances. And to try to do that creates real danger for families.
David, I don't know if you have thoughts too.
Yeah, look, is there some statistical point at which half the people are going to be upset one way, half the other? Maybe. But I'll tell you what doesn't care about middle ground is people's bodies and people's life circumstances, right? So whether it's something that's palatable to the majority of people in this country is irrelevant to someone who's suffering a lethal fetal anomaly that's past some point in pregnancy that someone determines is the point that's the middle ground, or they suffer other health consequences as a result, or their life circumstances change and they're with an abusive partner and they know that if they continue this pregnancy, they're going to be hooked to that person for the rest of their lives. And they need to get out of that relationship now, which might have been different earlier in pregnancy. And so circumstances change. There are reasons people get abortions later in pregnancy. And if we create some middle ground over a certain week in pregnancy, the people's lives, conditions, and bodies just don't pay attention to what the middle ground is, because it's just a different thing. And when we start legislating things that are so intimate and so much a part of people's lives and physical reality, it's not going to work.
And the middle ground is in violation of the Constitution.
Because of its protection of freedom and equality.
Oh, sure. And privacy.
And privacy. Alicia, this seems like maybe a question for you. What are some state Supreme Court races that you think are the most vital to keep an eye on that are coming up?
That's a great question. Well, this fall, there's sort of one main state Supreme Court race, which is in the state of Pennsylvania. So David may have thoughts on this as well. But that's a race that we'll be watching. The kind of future ideological composition of the court, is potentially something that could be in flux coming out of that election. And obviously, Pennsylvania is a very important state in a lot of different dimensions. It's a large state. It's a in our political context, it has often been, kind of a swing state. So it's something where state Supreme Courts are, potentially going to be very significant in a whole host of areas, not just in reproductive rights, but in hearing election cases and in other areas as well.
I can't resist. David, a while ago, you had a note about Missouri, something else you wanted to say about Missouri. The moment may have passed, but I'm very interested in Missouri because they have an effort to launch a ballot initiative for 2024 that has gotten mired in many different things. And I just wonder if you wanted to weigh in on that. Or something else.
Alicia was talking about some of the ways that state Supreme Courts have been involved. And I think one of the ways that the state Supreme Court in Missouri has been involved, which is just fascinating, is that the ballot initiative has to, by state law, have a cost estimate associated with it that's published to the citizens so they know how much voting one way or the other is going to cost the state. And the Attorney General of Missouri suggested or proposed that dollar figure would be $51 billion with a B dollars if they approve the right to abortion under the state constitution, which is absolute nonsense. But the litigants took it to the state Supreme Court and they agreed that this is nonsense. It's more like $51,000. I mean, it's just orders of magnitude different. But the Missouri Supreme Court, again, not known for being the most liberal Supreme Court in the country, put a stop to those shenanigans over this very important ballot initiative. So I just thought that was a funny story that I wanted to tell on top of what Alicia was talking about in terms of how state Supreme Courts have been involved with these ballot initiatives.
And I think there's a follow-up to that, which is that the Secretary of State in Missouri wrote summary ballot language for the initiative that would talk about abortion being dangerous and available up to birth, just very inflammatory language. And so now I think the Missouri Supreme Court, or maybe soon, will have a case challenging that summary, right?
Yeah, I mean, the battle here is not just over the ultimate outcome in these cases, in these initiatives, right? It's how the wording is, what's on the ballot, because the initiative might be longer, but there might be a summary on the ballot because people won't read all of it. So there's abortion is such a contentious issue that every part of this is being litigated with respect to these ballot initiatives.
Right. And all of this, of course, just sort of underscores the importance of state courts and of the Brennan Center's work on this issue, right? I mean, these are now issues that are front and center for state courts to decide, with the federal courts really taking a back seat or really having very little role at all. So I want to turn to our last question. What is the thing that you each want our audience to walk away from remembering this evening? Maybe I'll start with you, Chief Justice Beasley.
First of all, it is important to pay attention to Pennsylvania's Supreme Court races, but I hope, as we've discussed really critical issues this evening, that we all pay attention to every single Supreme Court race in this country. And Alicia and the Brennan Center will certainly keep us abreast of what those races are. What I want, the one thing I want every viewer to walk away with is everybody here is going to vote. Everybody here is engaged. But the one thing that I want people to walk away with from this session is to make sure that the people around us appreciate the value in voting and appreciate the empowerment in voting.
Did I lose you guys for a second?
Yes.
I had some weird
I think
refresh.
so.
Sorry, I'm back, at least momentarily. Alicia, why don't you answer next?
Well, what I would like folks to take away from this conversation is that state courts matter. They're powerful. They're often overlooked as critical sources of rights protection. And so I encourage people to get to know your state courts, get to know your state's constitution, and pay attention to these really important institutions.
David, last word. Actually, I get the last word. Almost.
It's really the combination of the two. It's that voting matters and state courts matter. So state court voting for state court judges matters. And it's really, there are a lot of people who think that when they vote in the federal elections every 2 years for Congress, every 4 years for the president, every 6 years for the Senate, that they're being an engaged citizen and they're doing their duty. But if you're not also voting in every state election, and many of those are in off years, so the odd years, and some of them are earlier in other parts of the year, if you're not doing all of those things, federal, state, and local elections, primary and general, that's a lot. I get it. It's a lot to know. It's a lot to pay attention to. But if you're not doing all of those things, you're doing it wrong. You need to be engaged in the political process at all of those levels, at all of those elections, because as both of my wonderful co-panelists said, it all matters. And in some ways, some of that matters a lot more than following, say, who the president is appointing to the US Supreme Court or to lower courts in the federal judiciary. The state courts matter in sometimes much more than that. And we need to treat them that way, and we need to act accordingly in our voting when we have a role in that. And if you're in a state where you're not involved in voting, there's still a way to have input through your representatives and other parts of the process. So we need to care about that and be involved in the process of how judges get onto the bench in the state.
Thank you for that. Thank you to all of our fabulous panelists. I know I learned a lot listening to all of you. And thank you to the audience for your great questions. I wish we had time to answer all of them. Please be sure to check out the brand new State Court Report website. It's at statecourtreport.org. You can sign up for the newsletter there to learn about live events like this one, and also to follow developments regarding state courts around the country. Thank you once again to our partner and co-sponsor for this event, which is the Birnbaum Women's Leadership Center. And the Brennan Center looks forward to seeing you at their next event, which is called Youth Rising, the Power of Latinx Voters. That is on September 26th. Be sure to register at brennancenter.org/events. I'm Emily Bazelon, a staff writer at the New York Times Magazine and Truman Capote Fellow at Yale Law School. From all of us, thanks so much for joining us this evening for this great discussion.